Welcome, everyone. I'm Kara Griffith, the President and CEO of Tax Analysts. I'm so pleased that you've joined us for this timely discussion on taxing digital advertisements and other products and the development of state laws to address modern technology. Today is the 9th in Tax Analyst series of public discussions that we call Taxing Issues. We launched this series in 2020 as part of our 50th anniversary celebration. And through the series, we are bringing together the tax community with leading policymakers and experts for bipartisan discussions on the future of tax policy. While I'm hoping that we can hold in-person events in the not too distant future, we will for now continue to hold these discussions in a virtual format. And we welcome your feedback on how we can make them more interactive. We also welcome your suggestions on future webinar topics. You can send your feedback or suggestions to events@taxanalyst.org. And now on to the topic at hand. At the state level, Maryland has been on the cutting edge when it comes to developing taxes for the digital era. Maryland enacted laws to tax digital advertising services and digital products, as well as digital code earlier this year, when the Democrat-controlled General Assembly overrode Governor Larry Hogan's veto of 2 bills. The first bill, House Bill 732, imposed a tax on the revenues received from digital advertising. Taxes imposed on persons that have global annual gross revenues of 100 million or more and digital advertising revenues sourced to Maryland of 1 million or more. The rate of tax is said to be determined on a sliding scale based on global annual gross revenues. Numerous business groups have opposed the digital ad tax. They say that it probably violates the Internet Tax Freedom Act because the tax would apply to digital advertising, but not to non-digital advertising. The second Maryland bill, House Bill 932, amends the term retail sale for purposes of the sales and use tax to include certain digital products. Along with taxing digital products themselves, the bill expands the sales and use tax to include sales of subscriptions to digital products, streaming of digital products, access to digital products, or the purchase of a digital code to receive or access digital products. While the digital products tax is less novel, the digital ad tax is truly novel. Maryland is the first state to tax the revenues derived from digital advertising, but several other states are considering similar proposals. Revenue from the digital ad tax has been earmarked for education. State lawmakers have been looking for ways to fund the state's $855 million education system overhaul without raising income, property, or sales taxes. Revenue from the new digital ad tax will go a long way towards reaching that goal. But the road that both bills took from conception to enactment was far from smooth, and we expect to see a few more bumps along the road. Maryland's Attorney General, Brian Frosh, didn't inspire a lot of confidence that the digital ad tax would survive legal scrutiny when he said that there is some risk that a reviewing court would find the tax unconstitutional. Nevertheless, Frosh said that he believes the tax is not clearly unconstitutional. To buy itself some time, Maryland General Assembly passed an emergency bill last month that would push back the implementation date of the digital ad tax and make some corrections to the expansion of the sales and use tax to digital products. Importantly, this new bill prohibits companies from directly passing on the cost of the digital advertising tax to customers through a separate charge. In addition, the bill further defines digital code and what items are not subject to tax, even if they are delivered digitally. The legislation now awaits the governor's signature. Maryland is certainly serving as a laboratory for democracy here, and a lot of other states are watching closely. To help us sort all of this out, we have an outstanding keynote speaker and panel. We will begin today with remarks by Eric Luedtke, the Majority Leader and Chair of the Revenues Subcommittee in Maryland's House of Delegates. He represents Maryland's District 14, and he was instrumental in the development of the digital tax bills. After Majority Leader Luedtke speaks, we'll have a panel discussion with 3 additional outstanding speakers. But without further ado, Majority Leader Luedtke, thank you so much for joining today, and we look forward to hearing your remarks.
Thank you so much for that very kind introduction and for inviting me. And thank you to Tax Notes for the work you do to educate people about tax policy. It's not something that all of my colleagues are super excited about, but as chairman of the Revenue Subcommittee, I find it really important and really interesting. As you say, I think this is a period where states are fundamentally reconsidering the structure of their sales taxes. And we're seeing significant shifts in the applicability of sales taxes. Perhaps, it's been no more significant than at any period in the history of the sales tax, going back to the implementation of retail sales taxes by states during the Great Depression. And as you say, these issues have to do with the transitions going on in our economy. And there are a number of those transitions that I'm sure our listeners here are familiar with. One, of course, is the gradual transition we've been experiencing for the last few decades from a goods-based economy to a services-based economy. And those conversations are still ongoing, but they're now caught up in conversations about the much more rapid shift to a digital economy. And I think what states are struggling with is that the sales tax has become such an important part of our revenue, and that if we do not modernize our sales taxes, we will either have to shift our sources of revenue to other types of taxes, which would require increases in things like the income tax or the property tax, or we would have to cut government. And that is particularly challenging, frankly, at a time where state governments are being tested as never before. We're seeing record applications for entitlements for unemployment insurance, record spending on emergency health care related to the pandemic. So yes, in Maryland, a lot of our focus has been on funding our schools, but the larger question is how states can continue to fund the basic services that keep our society and economy running if we don't implement tax changes to the sales tax. In Maryland, we have been fairly aggressive in making changes to our tax code. The digital goods and products tax was actually significantly less controversial, and many business groups didn't express strong opposition to it until, I should say, the interpretation, the guidance around some of the details of the digital products and codes tax came out earlier this year. And we did have to do some follow-up legislation, as you mentioned, addressing things like the taxability of semi-customized software, the taxability of trainings that professional associations and business associations offer. A lot of smaller details like that are important to get right and to clarify the intent of the legislature. And then, of course, there's the digital advertising tax, which, as you say, I think is an innovative proposal. I think the question of its legality or constitutionality is certainly going to be decided by the courts. There have already been cases filed challenging the law, and that's one of the reasons that we delayed implementation, to give time for the judicial branch to do its job and provide due diligence as to the legality of this type of taxation. But from my perspective, the fundamental question is, should companies that have this advertising-based business model essentially not have to pay any state tax in Maryland, despite the fact that they derive enormous benefits from our residents and our economy? I'm of the belief, and I think it's a basic belief, that a lot of the members of our legislature hold, and I think it's true of other legislatures in other states, that everybody should pay their fair share. And that's, I think, the basic political argument behind the bill. Now, of course, it is much more complicated than that in its implementation. And I think the courts will suss that out. The changes we made to the digital advertising gross receipts tax this year are, essentially intended to be clarifying changes. The provision that says that businesses cannot pass through as a line item the cost of the tax was a direct response to concerns expressed that the gross receipts tax would be billed to consumers basically as if it were a sales tax instead of a gross receipts tax, which is what it's intended to be. And the clarifications around the applicability to media organizations were also intended to be simply a clarification. But ultimately, as with many other policy issues and many new ideas in our governance and in tax policy, the courts are going to have their say, and that's where we're at in the process right now. So thank you for inviting me. I'm happy if we have time to answer any questions you might have, Kara.
Thank you so much. I have a couple of questions. You mentioned at the outset that this is an innovative proposal, and it truly is. Did you have a model, or was there an inspiration for this tax that you kind of based it all on?
So some European countries have been considering similar taxation schemes, and there was the original sponsor of the bill is actually our Senate President, President Ferguson, and I know he did look at some of those models, but primarily he was working with economists who were proposing this as an idea for expansion of the sales tax base.
Do you think it's the best way? I mean, you've mentioned on the idea of corporations paying their fair share. And so we look at these large social media companies like Facebook and Google. Is this the best way to tax them? Or is there some other way that might work better and accomplish the goal of having everyone paying their fair share?
It's a tough question, and it's rooted in, larger issues having to do with sales tax and nexus and, income tax and property tax, sort of the whole range of taxation. Companies like Google and Facebook do not really have a physical presence in the state of Maryland, but they have an enormous presence in reality, right? Our concept of a physical nexus as being important to taxation is a concept that's rooted in a pre-digital age. So is this the best way to go about it? There may be other alternatives out there. I think, should the courts strike down this version of it, I suspect that Maryland and other states will be looking at alternative ways to make sure that we have a broader base for sales taxes, and we're not overly taxing certain segments of society because we simply can't find a way to tax other segments.
Well, thank you so much for joining us today. We really appreciate it. I know that we're going to now have a fun discussion debating a lot of the issues presented by this. There's a lot here, but thank you so much for joining us. We really appreciate your time today.
I appreciate it, and I'll be listening, and I'm looking forward to listening as well.
So with that, let's turn to our panel. I think we have a lot of issues to discuss, and this is going to be a lot of fun. So our panel, we have three terrific speakers today. First, we have Nancy Prosser, who is General Counsel at the MultiState Tax Commission, where she provides legal support to the commission and participating states. We have Doug Lindholm, who is the President and Executive Director of the Council on State Taxation, a membership organization of nearly 550 multi-state corporations. Finally, we have Professor Richard Pomp, who is the Professor of Law at the University of Connecticut School of Law. Professor Pomp is a qualified expert witness. He serves as a counsel and consultant, and he is also on the advisory board for state tax notes. At the outset, I noted that we welcome your questions, and we absolutely do. Thank you to those who email questions in advance. If you'd like to submit questions during today's event, please do so using the chat feature. The panelists will discuss the issues at hand, and then we'll get to as many of your questions as time permits. I'd also like to mention that you can download any of the slides for today's presentation. And with that, I'm going to turn it over to Nancy to provide some background and some opening remarks for us.
Thank you, Kara. Good afternoon, everybody. It's great to be part of this program today. Thank you for the invitation. I want to say a few things about the MultiState Tax Commission, the organization I work for, and then give some thoughts about how I see this whole topic of taxation of digital products. I'm not sure what slides you're seeing at this point. One thing I did want to start with is a brief disclaimer that a lot of the remarks today will be my own. I will try and be clear when I'm speaking on behalf of the Commission. Next slide, please. Just quickly, I know we have some people that are participating from across the world and other countries today. So quickly about the MultiState Tax Commission. We are an interstate governmental agency, a .gov organization based in Washington, D.C. One of the important things to remember about the MTC is we focus on income, franchise, sales, and use taxes in our work. And we do our work in the public sphere. We very much encourage public participation in our different activities. We work under the MultiState Tax Compact, and our members are the heads of the departments of revenue throughout the country. And so right now, all states except basically one participate in some respect with our organization. Next slide, please. Our mission is threefold. That's to promote uniformity, to assist taxpayers with compliance, and then importantly, to advocate for state sovereignty over tax systems. Next slide, please. I guess I also wanted to mention that some of our program areas, we have a robust uniformity committee which works on model statutes and regulations. I'm part of a great team of 6 attorneys that provide legal support to the states, and part of what I bring to this discussion is also almost 16 years of working for the Texas Comptroller of Public Accounts before I came to the MTC. So I've worked around these issues for a number of years, and in thinking about preparing for today's program, I realized that, and as Kara kind of touched on, there's a sense that with this topic that the states are rather new to it, that they haven't been dealing with this for very long. But my experience says that actually some states have a lot of experience with this topic. And yes, there are some that are kind of dipping their toes in for the first time. But it led me to kind of come up with this, what I called brief and random history of events relating to taxation of digital goods and services. And these are just things that jump out at me as I've worked in this arena and with this topic over the years. And starting with, when did this even come on the scene for states to have to deal with this? And so by doing some research on the internet, it said 1989 was the first time we had a, internet service provider on a commercial scale. And then from that, the next event that really stuck out to me was 1998, when something called the Internet Tax Freedom Act was originally passed. And I know we're going to be talking about that a fair amount as we have this discussion today. But to keep in mind, for those of you who may not know as much about that particular federal act, when it was originally passed, the whole idea was it would be a temporary measure to put in place kind of a pause, if you will, so that this fledgling new technology called the internet would have a chance to get under its wings and be established before the states may do something through taxation that would cause a problem. And I'll note that there were states like Texas which were already imposing tax on internet access. So there were some that were along the way grandfathered until ITFA became permanent and the preemption in place. The other thing that I noted just from my own experience in Texas, and this question of have states been dealing with this issue, is in 2001 when in Texas the definition of taxable item was amended to add this statement that essentially says, the electronic version of a tangible item would still be taxed the same. Ergo, book you buy in the bookstore or one you download from the internet, the tax was going to be treated, the taxability treated the same. So again, 20 years ago that Texas put this into its laws. I also was mindful that we have, of course, the 24 or so streamlined states that work on uniformity with respect to sales and use tax issues. They've dealt with this a little bit in 2008, adopted something into their agreement. And then another major milestone for me is that 2009 to 2010 period when Washington State, after a couple of years of spending a lot of time working in conjunction with industry and legislature and the Department of Revenue, came up with a pretty comprehensive scheme towards and structure for taxing digital goods and services. Congress has come back into play again. 2010, we first saw the bill, the Digital Goods and Services Tax Fairness Act, hasn't been passed into law. We haven't seen it in this recent Congress, but I'm sure we'll see it again, which puts in place more of a sourcing regime for these items. And then since these are all more on the sales tax side of things, I wanted to note that, again, a work of the commission on the income tax side, that in 2017, it amended its regulations regarding to apportionment and allocation. and included amongst those revisions, provision that dealt specifically with sourcing of advertising. And I'll also note, even this week in state tax notes, there were 2 articles. Our friends there had a really interesting article where they noted this particular provision with a very positive mention in terms of the uniformity that helped to bring to the arena. And so, I just wanted to note that, it's not just been in the recent past that states have dealt with this, or the MTC, but we do have some experience. Next slide, please. Just also wanted to note that our Uniformity Committee, which is helmed by Helen Hecht, is just starting a new project on the sales and use tax side, which will focus on trying to take all of the things that we have learned in the past, and how can we look at putting together best practices for how we tax digital products in the world that we find ourselves. And you can find information about that project through our website. And again, we encourage public participation, and we know this is going to be of great interest to a lot of folks. Next slide, please. So my last slide in opening remarks on this topic, just my take on things, given all the years that I've now worked around this issue and looked at what's going on in the world, kind of came up with 4 key things and takeaways for myself. One is, I'm not surprised that legislatures are looking at this topic. It makes sense for them to look at their tax codes and try to bring them into, as we heard the legislator before us talking say, match the economy we're in with their tax codes. But as I've already noted too, second point, there are some states that have had some real success with this, who have a lot of experience with this. I mean, Washington State did a really nice presentation for the Uniformity Committee, and we're going to get that, I think, on our website for you to take a look at if you want to, about their experiences. But, and success for me means we get legislation on the books that people can understand, that the departments of revenue can administer and taxpayers can comply with, that does bring in revenue, but also takes into consideration that doesn't create great risks and tremendous costs for the taxpayers who are affected. Third, this is an MTC position, but also a Nancy Prosser position. From my years of experience, I don't think Congress is the right way and the right place to answer these questions. Because part of what we see is, once that happens, there's nobody to provide guidance on that front, leaving a gap. And usually these laws sit on the shelf, and it's hard to get any kind of revision to them. So lastly, my point is, what would SCOTUS do? And that is, we've got lots of cases, we've got things that are percolating through, but, is there a chance that we'll see the Supreme Court weigh in on this in some way that gives us more guidance about Commerce Clause issues, the anti-commandeering doctrine, and where will that lead us? So with that, I will pause and turn it back to Kara.
Thank you so much. That was very useful background. I appreciated that. Doug, let's turn it over to you.
Thank you, Kara. It's great to be here on this webinar. Just a couple opening prefatory remarks. From a policy standpoint, we have no objection to states expanding their sales tax base as long as they expand them to consumer goods, digital consumer goods. Where states run a little bit afoul of policy is if the digital goods they try and tax are business to business, that is business inputs. But I want to drill down a little bit on the 64,000-pound gorilla in the room, and that's the digital ad tax. I know that's the one that is concerning. That is not an expansion of the sales tax base. That is a separate gross receipts tax imposed on companies. And, fair disclosure, I'm the executive director of Cost. Cost has about 550 multinational companies, and many of the companies that are targeted under the ad tax are Cost members. So, but let me say, we're not anti-tax at all. We realize that taxes are the price that you pay for a civilized society, but we're very concerned about taxing companies the right way. That is, taxes cannot be cannot be discriminatory. They must be imposed in an equitable manner and in the way that is least harmful to economic growth and competitiveness. I'm not going to spend a lot of time in my prepared remarks on the constitutional problems with the ad tax or the violations of the Internet Tax Freedom Act. I think we'll get to that in questions, and I suspect Professor Pomp will touch on those as well. But I would like to touch on the origins of the ad tax, or what they call digital services taxes, or you'll hear me refer to them as DSTs in Europe. And Majority Leader Lidke referenced the fact that a lot of European countries are doing this, and in particular France. France was the first one out of the gate to target primarily U.S. companies with a unilateral tax. And I think 90% of the tax in France impacts U.S. companies. So it begs the question, why did France do this? Well, international tax rules are ill-equipped to deal with the digital economy. First of all, they have a permanent establishment rule that says unless a company has a significant physical presence in that country, the country can't tax them, can't reach them, no nexus. Secondly, international tax rules rely heavily on rules that allocate taxing rates to the location of the income producing activity and not to the location of the market state or the market jurisdiction. So in France, there was really no way that they could get to either the company or the income from that company that they saw as being derived from the subscriber base in France, right? So they took a unilateral approach and targeted U.S. companies. The U.S. trade rep immediately objected, and we got into this negotiation with France, and they agreed to make it temporary. Now, while this is going on, the OECD, the Organization for Economic Cooperation and Development, which is sort of like the MTC on a national scale, and that's a compliment, Nancy, has been working for the last decade on base erosion and profit shifting. And that is finding a multilateral way to make sure that big companies are taxed fairly. One of the offshoots of this BEPS project is what we call Pillar 1. And Pillar 1 acknowledges the weaknesses that I just discussed and tries to fix them. And what they propose is, one, get rid of the permanent establishment rule and replace it with an economic presence rule, or a significant economic presence rule. And number two, specifically allocate some of the taxing rights to the jurisdictions that aren't getting them now. That is the market jurisdictions, like the subscriber bases. So there's a precondition, however, in Pillar 1 that says that if we're going to adopt this multilateral approach, then there has to be acknowledgement that all of these DSTs are temporary and will be withdrawn before Pillar 1 is agreed on. Now, nearly every country, now there's about 25 or 26 that have looked at this, has said, yes, these are temporary. If we get to a Pillar 1 agreement, then we will withdraw them because there's no need. Now, let's compare that to the state rules, right? So the states are the same flaws present in state corporate income taxes as in the international tax arena? Absolutely not. And let me tell you why. First of all, ever since Wayfair, every state, except Delaware, I think, has imposed an economic presence rule to exercise taxing authority over companies. So Maryland can indeed get to those companies through their corporate income tax. Secondly, most states have moved over the years to either a single sales factor or a heavily weighted sales factor. And I think Maryland, a single sales factor goes into effect in next year. And that, again, is a move toward the market, right, where the sales take place. And finally, and I referenced Nancy's, the MTC Section 17 regs that move states to market sourcing. More and more states, and I think we're up to around 33, now impose market sourcing, which sources the sale of advertising services specifically to the location of the customer. So Maryland can indeed get to this income from these big companies. Now, I want to give a shout out to two of my colleagues here, Carl Frieden and Stephanie Doe. Nancy referenced the article that they wrote. It is called State Adoption of European DSTs, Misguided and Unnecessary. published in Tax Notes States just 2 days ago. I highly recommend it. It goes far into more detail than the 4 or 5 minutes I have here. So in effect, what's going on since the state corporate income tax rules have adopted and evolved to address the digital business model, there is no need to go after it, to ring fence a specific company and go after them in an aggressive way, and in a way that most economists will tell you gross receipts taxes are very, very poor way to reach companies. Now, one final point I'd like to make, and I'd like legislators who are listening and state legislators to take a look at the big picture. Adoption of state digital services taxes or digital advertising taxes really puts our government, our national government, in a bind on the global in the global arena. We oppose those, and this is bipartisan opposal or opposition. Both the Trump administration and the Biden administration both oppose the unilateral national adoption of digital advertising taxes. And I'll tell you, that's very rare that you get consistency like that. Now, imagine Secretary Yellen, our Treasury Secretary, in a meeting with the G20, trying to convince them that these digital advertising taxes are bad and should be repealed. A very easy response. Well, you can't. You have no leg to stand on. Your states themselves are imposing the very same tax that we want. So just recognize that the U.S. we have a huge economic advantage with our tech companies, and by all means, states should tax them using the full array of their tax structures now, corporate income taxes, sales taxes, and by the way, businesses pay 40% of sales taxes, which are on business inputs. Property taxes, a whole host of other taxes, employment taxes, payroll taxes, et cetera. But don't go out of our way to discriminate against a specific sector of companies that just because they're doing well, when you can already reach them through your existing tax structure. Unfortunately, a new untested tax like this is going to be very painful from a litigation and a planning standpoint. So I will stop there and turn it over to my colleagues.
Thank you, Doug. You make a good case against this. So let's hear a little bit more maybe on the legality and the constitutionality from Professor Pomp.
Yes, first, this pirate's patch is not a political statement on how the Facebooks of the world are pirating our data. I had surgery this morning and this patch was free. The painkillers were free, so I took a couple of free souvenirs with me. And very happy to be here, at least until the souvenirs wear off. And thank you, Kara. This is another wonderful panel in what has been a series of just terrific panels. So my compliments. Doug, with his usual eloquence, of course, leaves out one or two pretty major points. I have heard Mr. Lutke earlier, let's see, maybe it was last month, talk about that Maryland is not getting its fair share of some of these large players like Facebook. And he has a wonderful point. Facebook posted US net income about $20 billion end of 2020. I don't know what share of that Maryland is getting, probably not its fair share. I agree with Mr. Lutke on that. Why? And this is the point Doug, in his excitement, of course, just seemed to overlook. Maryland is a separate entity state with no throwback rule. So a little point that ought to be put on the table. And I can only think of the incongruity of our being here, lamenting the lack of fairness that requires a misguided, in my opinion, tax on digital advertising without closing these blatant gaps in Maryland law. You might as well put a sign on I-95, the major north-south highway coming into Maryland, home of voluntary compliance, because that's what it means when you're a separate entity state with no add back, no throwback, or they have a modest add back for intercorporate transfers. You just don't control your own tax base. And it is somewhat ironic that at the same day there was a hearing on this bill, there was a hearing on a bill to introduce combined reporting and a throwback rule. And who testified against it? Well, Doug unleashed his dogs because they're very good, they're smart, they're eloquent, and they testified against the bill. Probably the single most important thing Maryland can do to take control over its tax base. And their argument is based on something that happened back in 2007-8. You remember recession years in this country. Maryland was thinking of combined reporting then, and they did something that made sense. It said to the companies, file pro forma returns as if we had combined reporting. But of course, they left out a lot of the details on what the rules on combined reporting were going to be, how you're going to handle losses, credits, instant unity, all of that, net operating losses, and various apportionment formulas, different apportionment formulas for members that were going to be combined. And so it wasn't the most rigorous pro forma set of returns that one has seen. It was a bit like asking the fox to design a lock on the hen house. You can't help but think that folks who did not want combined reporting calculated their pro forma returns to suggest it would not be a good thing for Maryland. It showed losses. Well, maybe not surprising, given that it was 2007 and 2008. And that is what gets thrown up every time Maryland discusses combined reporting. And it's about time we reject that mantra and move beyond that. And there are ways to control losses that might result from combined reporting. And of course, no one asked the question, how much would Maryland save in administrative resources that go into guarding a separate entity regime from taxpayer abuse? So if you're worried, and as any state should be, but if Maryland is worried about some of these big companies like Facebook, Google not paying their fair share, they certainly have it within their power to correct. And as Doug correctly noted, and that is a great article by Carl and Stephanie, we are no longer are saddled with that physical presence rule. We have economic nexus. Our sourcing rules have moved toward a market-based approach. And that means you can get a lot of money that you previously weren't getting. But if your base is defective because it's on a separate entity basis, you're not going to pick up that money. And so, I mean, I will turn maybe as we move into the questions, Kara, to the digital advertising tax. But for now, I just want to, I would have asked Mr. Lutke, while this bill was being drafted, all of the defects were brought to the attention of his committee and more generally the General Assembly and the Attorney General. Not one change in the bill was made in response to these complaints. And you have to ask yourself, why not? I mean, some of them were remediable, so why was nothing done? And I have to wonder whether this bill isn't a stalking horse, this law now isn't a stalking horse for combined reporting. I mean, maybe that wasn't the intent, but it could well be the result. The revenue is earmarked for education, a laudable goal to be sure. And there's a lot of the beneficiaries of that earmarking that I'm sure already have the money spent, because that's the way it usually works. They're going to be chagrined when they realize that the money is not going to be forthcoming, in which case they really now become allies for getting something in place that will generate that money, and that something will be combined reporting. And rather than Maryland take great pride in being the first state to have a defective tax on digital advertising, maybe it could join the nearly 30 states that have combined reporting. And if they really want the distinction of being the first, they could adopt worldwide combined reporting, which by some estimates will raise over $300 million, more than this law was estimated to raise, but probably won't see a penny. And that may turn out to be the silver lining. So Kara, back to you with wherever you want to take us.
Wonderful, thank you. So Doug, I have to give you an opportunity to respond here to the idea that, and I asked Delegate Lutke on if there is a better way to tax the Googles and the Facebooks and the social media companies, and Professor Pomp suggested that perhaps combined reporting is the right. And so I want to give you an opportunity to respond and give your side of the coin on that.
Yeah, thank you, Kara. You know, Professor Pomp, this is, I'm not sure why he is chewing on this like a terrier on a bone, but the difficulty with combined reporting in Maryland, more than a lot of states, took a very, very intense study of what combined reporting would mean for the state. They forced companies to do a pro forma. Companies did that. They called thousands of companies as a follow-up. Professor Pomp said they left out some of the details. Well, all that does is highlight the difficulty of defining what a unitary group is and what should be in that base. And the difficulty here is that the result of that pro forma testing found that combined reporting would actually make the state corporate income tax more volatile than it is now. There would be greater losses when a recession, greater income in an uptick. Do you really want a more volatile tax? And the legislature in their wisdom said no. I still think that combined reporting, because it is a judicial doctrine, is hopelessly vague. Who knows what functional integration, economies of scale, centralized management actually mean in the real world? And again, it's very, very difficult to administer, very difficult for taxpayers, especially if it encourages both taxpayers and the states to cherry pick on who is in the unitary group. So, I don't think that is an answer at all. He also referenced worldwide combined reporting, which was an idea that was thrown out by California way back in the 80s that created threats of retaliatory taxation from some of our biggest trading partners, the UK and Japan. And ultimately, a committee established by Treasury Secretary Reagan shot that down as not something that you should do. So I love Professor Pomp, but sometimes he sits up in his ivory tower and has never had a chance to file a unitary return or go through a unitary tax audit. So, I don't think that unitary is or would be an effective stalking horse to replace this ad tax at all. So I'm sorry that we seem to be getting off topic here, but.
All I can say, it must be 30 states are just wrong then in the country. And when did California start to do combined? Probably the mid 30s to deal with the movie industry. That's nearly 100 years of experience. But okay, we'll move on.
I don't think the states that have adopted combined reporting have seen the revenue jump that you're talking about. $300 million?
That's on worldwide. That is the estimate for Maryland on worldwide.
That's based on
IRG.
That's the ITEP report that is based on a wildly exaggerated estimate of global profit shifting and how much it might impact the state.
Yes, yeah. The numbers you don't like are always wildly wrong. So,
well, again, the hundreds of millions of dollars have not come forth in the other states that the ITEP projected as well. So.
All right, Kara, on to the bill and the law now in front of us.
So Nancy, I'm going to turn to you on it's somewhat of a similar question, but is the digital ad tax sound tax policy, or is there, it does come back to a similar question of, is there a better way if this is not sound tax policy? What's your take on it from a multi-state perspective?
Well, and again, I guess I look at this as I'm sitting here as the tax administrator. So we're the people that are given these laws to try and figure out how to help people comply. I don't see my role here as saying it's good tax policy, it's bad tax policy. That's for the legislatures to determine. And keeping with the mission of the MTC, you know, we support the right of every state to have whatever tax structure they think is appropriate. You know, so it's not for me to say it's good policy, it's bad policy. You know, I will say though that getting back to one of my earlier talking points, to me, a successful piece of legislation is one that, you know, is understandable and administrable, able for taxpayers to comply, and you know, balances the revenue raised with any of the burdens and costs to the taxpayers. This is a new approach to state taxation, and you know, if the goal is modernize your tax system and you know, do it in a way that you know, reflects good tax policy in a sense, or policy that is proven, I should say, then as I noted in my introductory comments, you know, there are states that have experience with this, that have been able to do it. And, you know, instead of doing something new and generating a lot of expected litigation that may take a while to work its way through the system, you know, I'm excited about this project the MTC is undertaking to, you know, look at on the sales tax side, where can we take the successes we know exist and build on that, and, you know, build on what MTC and other states have done even on the income tax side. So that would be my response to that.
I think it's going to be one of those taxes where the guidance that comes out is going to be incredibly important for taxpayer compliance purposes, as well as for administrability. It looks to me like the Maryland law determines the taxpayer's tax rate based on income that includes what the taxpayer earned outside of Maryland. I'm curious from all three of you, is that legal to determine a taxpayer's tax rate based on their income earned outside of the state? So Professor,
yeah, indeed. It's based on their revenue, worldwide revenue. The more revenue you have outside of Maryland, the higher your tax rate is going to be, even though that rate will be levied on only Maryland advertising, yet to be determined how that decision will be made. And that's just so contrary to what we know from the corporate income tax. The more outside the state activities you have, the lower the your tax in the state, and it violates the Constitution. It violates a number of provisions. We could dig down deeper if you want, but just to get it on the table, no, that is one of the many defects in the bill. It's just a comment on things that have not received the same attention. That point, I think, has received attention. What has been less obvious is this tremendous notch effect that is in the law. When you put your slides up, if a taxpayer has worldwide gross revenues of $1 billion, the rate, I believe, is what, 2.5%. But if they have $1 billion plus $1, $1 billion in one, that rate goes up to 5%. It doubles. And that is what economists have called a notch effect, that normally we don't have progressive rates greater than 100%. That's just a very odd way they drafted the rate structure. I don't know exactly why. It's certainly not inevitable it be done that way. It's interesting that they're so embarrassed by this that they won't let the taxpayers separately state the tax on an invoice or show it or itemize it. Maybe that's unconstitutional. Some of my colleagues who teach more First Amendment jurisprudence than I do suggest that it's commercial speech and that is protected under the First Amendment. So that may be an issue, but they've turned it into this stealth tax. I mean, which it really starts off being anyway. And then they've aggravated that feature of it by saying, you can't even itemize it if you want. It's not that you can't increase your prices by the tax. You can. No statute can repeal the supply and demand curves that determine the economic incidence of a tax. That's what determines whether tax can be passed on or not. All this does is hide the cost of government from voters. And so much for openness and transparency in the financing of state government. It's interesting to compare that with the sales tax, which you notice Mr. Lutke kept transposing sales tax, gross receipts tax. These are very different animals. In the sales tax, separately stating the tax is routine. In fact, retailers lobbied for that back in during the Depression when many states adopted a sales tax because they wanted to show consumers, hey, don't blame us for that additional 2%, which was a common rate in the old days. Don't blame us for that additional 2%. That's what the government is making us do. And there was probably also a signaling saying to everyone else retailing, keep your base price the same and just separately itemize this at the end. But if this were really a sales tax, which it is not, it has none of the attributes of a sales tax, except for the fairly high rates, more common of a sales tax than a gross receipts tax. But a sales tax has, at least makes efforts to make sure the tax doesn't fall on business inputs. It has a purchase for resale exemption. It has an ingredient component exemption. It may have a manufacturing exemption, the goal of which, as Doug did mention, and I'll throw out an olive branch to him, I agree with him on this, that a sales tax should fall on ultimate consumption by the end user. This is a gross receipts tax. It's a turnover tax. It's a kind of tax that's been condemned and vilified and mocked by economists for at least a couple of 100 years. It is what led to the value added tax in Europe, which overcomes many of the defects in a turnover tax. This is really nothing to be proud of to say we've adopted a turnover tax. And then we have the Internet Tax Freedom Act. But I could stop at this point, Kara, and let people just respond to what I have said, and then we could circle back on the Internet Tax Freedom Act.
If I could make 2 points all in agreement with Professor Pomp. First, anytime you've got a tax based on conduct by the taxpayer that takes place out of state, it violates at least the fourth prong and external consistency of the enforcement prong of complete auto. I have a problem with that. The issue we haven't really talked about, Kara, you referenced guidance forthcoming from the comptroller. The tax is currently in effect right now. Taxpayers have already had to figure out what their first quarter estimated payments were and send them in with absolutely no guidance how to determine what the tax base is. If there's ever a poster child for due process violation, this is it. When is that guidance forthcoming? How will it happen? What will happen to taxpayers who've already, have underpaid, estimated? I mean, very, very, very difficult. And the Internet Tax Freedom Act, and I'd love to hear Professor Pomp's and Nancy's take on this as well. That to me seems to be the biggest impediment. I want to reference the AG's letter that said that this is not clearly unconstitutional. I thought there was a very interesting explanation for that. And his explanation was because you can pay for digital advertising not through the internet, that a court may suggest that the transaction is therefore not discriminatory. I guess that you can write a check for digital advertising, or you can go to the cash window at Facebook and pay cash. You know, to me, it's a bit of a stretch, and I think the AG was wise to couch his words as not clearly unconstitutional, but I think they have some real problems in the courts. And Professor Nancy, I'd love to hear your thoughts on that as well.
Well, one thing, Doug, is I thought that the tax effective date had been moved back, and that the first payments are not due until, according to the bulletin, until April of 2022. So,
all right, yeah, then I may, yeah, that if they,
yeah, I think that was one of the legislative
Okay.
changes. So there is
Fair
more
enough.
time there. And I agree that was a good move by the legislature to give everybody, including the Department of Revenue, and give that department its chance to get out the guidance that I'm sure they're actively working on, and that taxpayers deserve. And so let's let the department, do their job. In terms of these various claims of unconstitutionality, we know the lawsuits have been filed. We've seen their side of the story. I will just say, again, working with the departments of revenue, with the MTC, I think, I want to give the state a chance to defend its law, give the attorneys who've been assigned the cases to, work through them and figure out what they believe about the cases and these constitutional issues, and, do the discovery and the research to respond to the claims that have been made. So, I'm going to support the department, support those attorneys, and let them do their jobs, and let's see what they have to say in response to the cases that have been made.
I'll tell you what they're going to say, because it's certainly no mystery. They're going to say that offline advertising is not the same as digital advertising. Any claim of discrimination requires comparing two transactions or activities. And it presents a level of generality problem, which is ubiquitous in the law. There are many levels at which you can describe a transaction. I mean, just take those of us here. We could be described most specifically according to the sequencing of our DNA, and that would be very specific. We could be described most generally as being part of the Homo sapiens group. What level you think is relevant is not always a matter of a priori logic. If you want stability in the law, you don't want every year someone coming in and saying, well, our form of advertising is different from what has already been decided to be acceptable, but we do it in a different way. And we know how technology is evolving. We know there's going to be lots of differences going forward. You really want the most basic level of generality, and that is advertising versus advertising. And if you cut too fine a point on that, you're introducing an instability into the law. You're never going to be done with the litigation. So you can bet, this is a pretty safe bet, that the argument over the Internet Tax Freedom Act will reduce to offline advertising is just a different beast from online advertising. Well, we know that. That doesn't tell us very much. So,
And you're right, Professor. To me, that's one of the big issues here with the Internet Tax Freedom Act is we don't have a lot of experience litigation-wise. How do you set up those comparison classes, right? I mean, what are you going to compare? And that's one of the fundamental problems I have with the Internet Tax Freedom Act. And, I know this is one of the questions is this an opportunity to take a closer look at that particular federal act? I still have fundamental problems with the idea that Congress can just say, hey, we don't like the states imposing a tax on this particular type of activity, so we're just going to tell you you can't do it. Again, drawing on my experiences in Texas, when the internet came into being, Texas was already had in place a tax on telecommunications services. Its definition covered without question, a sale of internet access service. And, at the time that the permanent ban has now gone into effect as of last year, Texas is losing something like $500 million a year in revenue. And this is through a tax on a service that, through my experience, Texas, the way it had structured it, and it was one of those good taxes in that it was understandable. It didn't generate a lot of disputes or any real litigation. So it met my, best practices of tax approaches and tax legislation. And yet now we have, look at all this, challenges that we're going to continue to have as we move through this growing digital economy, that now we've got this federal act that is sitting there, and will Congress ever look at this again? So, I really have problems, and this is where, I hope maybe whether it's this piece of legislation and litigation, or maybe there will be other cases that come down the pike. But I think it's a real question whether or not Congress should just be able to say, we don't like you states having a tax on this particular item, and so you can't do it. So, I mean, we could solve this problem if it just went away.
So do you think this will be an opportunity to challenge the constitutionality of the Internet Tax Freedom Act? I mean, could we get that far with litigation on the Maryland digital ad tax?
Well, I think it's possible. I mean, there are arguments out there that folks have made that to look at what was really intended by the Commerce Clause, and whether or not through the Murphy case. I'll be interested to see, with the challenges that we've seen to the American Rescue Plan Act, the states that have filed suit to challenge the provision that says states can't put in place any kind of tax cuts. Does that present an opportunity, if those cases get up to the Supreme Court, to give us some more guidance on that particular issue? Because, and this is one of those things, it would be helpful to know, if indeed Congress, through the Commerce Clause, has this very broad ability to just say, again, we don't like states imposing a tax on X thing, or, we want to protect this industry. Therefore, sorry, states, you're out of luck.
Yeah. Well, there's gonna be a lot to watch for sure. I will note that Jim Dawson put in a comment that the Maryland legislation that extends the application date of the tax has not yet been signed by the governor. So the law, as it is on the books, is currently in effect and became effective 30 days after February 2nd, though it is his understanding that the comptroller is not accepting estimated payments at this time. So just a side note, thanks to Jim for that. Well, I can't thank you guys enough. This was as much fun as I had hoped. It was a very interesting and engaging discussion, and I thank you all for your time, and we could go for another hour. So maybe we'll have to have a follow-up sometime soon. But I thank you, and I thank everybody for listening, and I hope everyone has a great rest of their day.
Thank you, Kara.
Thank you.